Good afternoon. Welcome to the Committee on Labor, Culture and the Arts. This is a hearing on three House bills. Today is Wednesday, March 17th. It is 3:30 p.m. and we are in conference room 225. As a matter of housekeeping, this meeting, including the audio and video of remote participants, is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business on Friday, March 19th in room 225 at 3:10 p.m. For those of you on YouTube, if you'd like to submit testimony, you may do so on the legislative website until midnight tonight. Okay, we'll proceed to the first of the bills. This is House Bill 465, House Draft 1. This is relating to collective bargaining. It clarifies that the representative of labor on the board, on the Hawaii Labor Relations Board, be a person selected by a majority of the exclusive representatives of the collective bargaining units. It establishes procedures for removal of the representative of labor on the Hawaii Labor Relations Board. Testifiers, we have Office of Collective Bargaining. Yeah, Mr. Wada?
Aloha, Chair.
There he is.
Chair,
Okay.
Vice Chair, members of the committee, Riker Wada from the Office of Collective Bargaining. We did submit written testimony, and we'll stand on our written testimony with just two quick points. One is just to reiterate the same point we made in the last hearing, that really the concern here is that this diminishes the governor's authority by compelling him to appoint a single individual. And the second point is we did follow up in the last committee hearing with the companion bill, following up with Senator Ihara's question regarding if there are any other boards where the governor's power to appoint is basically ministerial. And as far as, according to the State Office on Boards and Commissions, there are no other boards that they're aware of that have the same type of ministerial appointing. I'll be happy to answer any questions. Thank you.
Thank you. Hawaii Labor Relations Board.
Thank you, Chair, Vice Chair, and members of the committee. Midori Hirai on behalf of Marcus Oshiro and the Hawaii Labor Relations Board. We've previously emphasized that there are two parts of this bill, and the second section, as written, removes a board member's neutrality and accordingly will irreparably damage the board. I can go further into this irreparable damage if the committee wants. The Senate Committee on Judiciary included a note in their standing committee report on the companion bill, questioning whether this second part is constitutional and in line with how other boards and commissions are treated. It is neither. The Hawaii State Constitution allows members of boards and commissions to be removed as provided by law, but it also requires, as does the U.S. Constitution, due process. This second part of the bill does not provide due process. Based on seat designation, a member of the board is subject to removal by an interested party without cause, without opportunity to defend themselves, and without opportunity for appeal. I won't reiterate our position on the second part of the bill further. However, as to the overall bill, the board wants to make it clear that under the current law, the public sector unions, by mutual agreement, select 3 people they believe are representative of labor and submit those names to the governor. Every single public sector union agreed that those who fill and have filled the seat representative of labor is representative of labor. They mutually agreed to those names. Under current law, whatever background is required to make someone representative of labor is up to the public sector unions to decide. When creating the board, the legislature did not state that the members would represent any party. If the legislature intended to have board members represent the parties, then the parties do not need to provide their own advocates. The entire way the board functions would have to change if the members are intended to represent parties, because then the board members are no longer neutral decision makers bound to the rule of law. As it stands, the board, as a quasi-judicial body, has an obligation to be neutral and fairly apply the law, regardless of their backgrounds and seat designations. If the legislature wants to change this and have the board represent the parties, the board submits that the sections of the HRS surrounding the way the board conducts business must be changed. Thank you for the opportunity to testify on this measure, and I'm available for any questions.
Thank you. Let's see, HSTA.
Good afternoon, Chair Taniguchi, Mitsuhiga, speaking on behalf of Wilbur Hope, our Executive Director for the Hawaii State Teachers Association. And we'll just briefly stand in our testimony, but state that this is about not being a representative for labor, but a representative of labor. An understanding of labor is very important to be on this board, and that is all we're asking. Thank you.
Thank you. Hawaii Government Employees Association.
Thank you, Chair. Good afternoon, Chair, Vice Chair, and members of the committee. Michelle Kurihara-Klein on behalf of the Hawaii Government Employees Association. You have our written testimony before you, which is in very strong support of the passage of this measure, and it outlines several aspects that the previous two testifiers prior to me had testified to. I wanted to add on that it is our understanding that the Constitution does allow for this removal process because it is very specific to state that it is that removals of members shall be as provided by law, and that's written in the Constitution. I'd be happy to answer any questions that you might have about this legislation. Thank you.
Thank you. United Public Workers also submitted testimony and was going to testify but had to sign off, so we do have their testimony in support. We also have testimony from the University of Hawaii Professional Assembly also in support. Do you have any questions from members?
Yes.
Senator Ihara.
To either or both of the labor union representatives, legislation requires the agreement with the executive, and the governor needs to approve. And I wanted to ask, is there a fall? Well, you may not want to say, but you may be looking at a fallback position or another way to accomplish the goal that you seek, short of this bill that appears that the executive branch is in opposition to it. Any thoughts from either of the labor unions?
Vice Chair, I'm sorry, I might not be understanding your question. Are you asking if there's another?
Yeah, is there another way?
Point?
Yes. Yeah.
Well, go ahead. I'm sorry.
No. If there's another route or another way to accomplish the concern, the underlying concern that this bill seeks to address.
Unfortunately, we don't believe so, and we feel that this was the best resolution, and which is why we, in concert, the 6 public sector unions had agreed to submit and put this bill forward. The bill does outline that a simple majority of the unions need to be in agreement for either action, whether it be the nomination of the individual or the removal of the sitting labor representative. But because there are 6 organizations, it's actually a supermajority because 4 organizations would need to be in agreement. And I think anyone who pays close attention to what the public sector unions do knows that 4 unions in agreement is a very high threshold to reach. And so unfortunately, this was the best and fairest process that we could think of.
Okay, I had a follow-up. So let's say the situation is that this bill is challenged in court for being unconstitutional for, in the loss, the issue would be, the Constitution requires the governor to appoint boards and commissions, and it is a ministerial process that the governor appoints a member to a board or commission in a ministerial way. It's a ministerial act rather than an appointment, because if there was two, then there was a choice. Ethics Commission and I think Campaign Spending Commission nominees, there's two and the governor picks one of the two. So have you folks thought of, or do you have, you're prepared for, or can you address that kind of assertion, challenging the inadequate, if someone alleges an inadequate ministerial appointment and it requires a real appointment?
Sure. So the 6 public sector unions have not discussed what would happen in that case, or if collectively we would be willing to allow for 2 versus 3 nominees. I think it's important to also note that it's been challenging to find 3 credible applicants that we could nominate. The industry is quite small and is very reliant upon experience. So it has been a challenge in the past to even find 3 credible names. We thought this would be a means to address that. So unfortunately, I couldn't speak to whether the unions collectively would want to seek amendment to allow for 2 seats. One thing that internally at HGEA we had been tossing around was the idea of severability clause, so that if either of the provisions are found to be unconstitutional, that whether it be the appointment or the removal provision, that one would not affect the other. And so I think we would be generally open to inserting a severability clause. But again, I couldn't speak on behalf of all of the 6 public sector unions. So
you believe that it would be difficult, what it seems to, on the 2, a choice, if I think 2 would meet constitutional muster on its face. And so the 2 questions. One is, do you believe that one is, will the other unions agree to 2? And the second question is, even if you did, would you be able to find 2 names? And I thought I heard you indicate that it's difficult to even find 2 names. Is that correct?
Yes.
Okay.
It's difficult to find, the challenge is often that we would want someone who has a comprehensive background, not only in labor in general, but in local Hawaii public sector labor in particular. And just that, that depth of experience is very rare to come by. And that poses a challenge. So, if I'm being completely frank, it could be where we are searching high and low just to find 3 willing and able names, but that 1 or 2 of them does not necessarily meet the qualifications that we are wanting or looking for collectively as the unions. And that would then empower the governor to be able to pick someone who doesn't meet the qualifications that we would support, because we had to arbitrarily provide 3 names. And that, I think, is where the issue lies. And that's why we wanted to ensure that there was 1 name that the majority of the unions agreed upon that could be submitted and moved forward.
Okay, thank you.
Okay.
You're welcome.
Thank you. Further questions from members? Any further questions? If not, thank you. We'll proceed to the next bill. House Bill 670, House Draft 1, relating to the employees' retirement system. This authorizes forfeiture of certain ERS benefits pursuant to court order for state and county employees and designated beneficiaries who are convicted of an employment-related felony. Testifying, we have the employees' retirement system, Mr. Williams. can't. Oh, we can't hear you.
Chair, Vice Chair, members of the Roy Marble, Deputy Executive Director for the
I can't hear.
Yeah. We can.
Supports this bill and stand on our written testimony.
Is there a way, we can't, sorry, we can't hear you real well. Yeah, maybe, where's your mic or what? It's real soft, we can't.
Yeah, get close to the mic.
Yeah, how's that? Try,
And
test,
talk loud.
try and test that.
Okay, try. Is this better?
It's just a little better. um,
Is this better?
yeah, you gotta yell. Okay, I think what I made out was that she stands on the written testimony with comments. Okay. We have Common Cause Hawaii.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma
Mhm.
for Common Cause Hawaii. We support HB 670 HD1. This measure is to restore faith in government and government employees. This measure is not about punishment. It's not a mandatory forfeiture. And so these are the reasons why we support this measure. I'm available for questions. Thank you.
Okay, thank you. We have 4, 5, 6, 7, 8. We have 8. We have 8 other testimonies in support that we've received on House Bill 670, House Draft 1. Are there any questions from members? Questions? All right, then we'll proceed. Thank you. We'll proceed to the last bill, House Bill 1253, House Draft 3. This is relating to employment practices. It prohibits employers with certain exemptions from requiring employees to download mobile applications to the employee's personal communication devices, terminating or otherwise discriminating against employees for refusing to download mobile applications, or discharging or discriminating against employees for filing complaints concerning these unlawful practices. We have one testifier from the Chamber of Commerce of Hawaii, Mr. O.
Aloha, Chair,
Aloha.
Vice Chair, members of the committee. Myung Oh here on behalf of the Chamber of Commerce. We'll stand on our written testimony submitted, but I'll be available for any questions that the committee members may have. Thank you.
Okay, thank you. We also have the Department of Labor Industrial Relations in support. I don't think they're on. We have comments from the Society for Human Resource Management, and we have 2 other written testimonies in opposition. Okay, do we have questions from members? Okay, if not, I guess we'll go into the breakout room. So we'll recess the welcome back. This is the Committee on Labor, Culture and the Arts. This is our 3:30 hearing. We had 3 House bills that we heard testimony on. And now we are in decision-making on those 3 bills. So with regard to House Bill 465, House Draft 1, relating to collective bargaining, this is a bill that deals with the Hawaii Labor Relations Board. We did pass out Senate Bill 678, which is very similar and to this House bill. The chair will recommend we pass with amendments. We will delete language because it is an unnecessary description on page 3, lines 5 to 6. And we'll delete the language which limits the appointment of a member of a board or commission to 2 terms or 8 consecutive years. And then we'll make technical, non-substantive amendments. I think we'll keep the effective date to upon approval. Okay. Any discussion from members? Okay. If not,
Ready for the vote?
yeah, take the vote.
Okay, Labor Committee members, we are voting on the Chair's recommendation to pass HB 465 with amendments as stated. Chair Taniguchi.
Aye.
Vice Chair votes aye with reservations. Senator Chang.
Aye.
Senator Keokolole.
Aye.
I'm sorry.
Aye.
Okay. And Senator Favela. Reservations. The recommendation is adopted.
Thank you, members. We'll proceed to House Bill 670, House Draft 1, relating to the employees' retirement system. This is forfeiture in cases of conviction of an employment-related felony. Let's see. We did pass Senate Bill 912, Senate Draft 1, which dealt with this bill, which dealt with this subject. And so chairs are going to recommend that we amend the bill to go back to the provisions in Senate Bill 912, Senate Draft 1. So recommendation is to pass with amendments. We'll amend to provide that the civil penalty would be 1/2 of any benefits instead of all or a portion of the benefits. We'll clarify that upon the death of the convicted member, the designated beneficiary would receive the reduced benefits to which the member, former member, or retirement would be entitled under this section. We'll amend to provide that a designated beneficiary convicted of a felony based on the same circumstances as the member, former member, or retirement would receive no benefit under this section. We'll defect the date to get more discussion on this to January 1st, 2050, and make technical and other non-substantive amendments. Do you have any discussion from members? Discussion? If not, Senator Howard.
Okay, Labor Committee members, all of whom are present, we're voting on the Chair's recommendation to pass House Bill 670 with amendments. Chair Taniguchi.
Aye.
Vice Chair votes aye. Senator Chang.
Aye.
Senator Keokolole.
Aye.
Senator Favela.
Aye.
Recommendations adopted.
Thank you, members. Last bill, House Bill 1253, House Draft 3. This is relating to employment practices. This is regarding the requirement to download mobile applications on employee's personal communication device. Let's see. I think the main crux of this bill is that I think the chair doesn't want to have to force employees to, on their personal devices, to have the employer require them to have apps that would be able to trace them. And so I think we put the onus, I guess, on the employer so that we would require that the employer employer would provide, I guess, an instrument for use, and that the employee would be required to carry it in those kinds of cases, rather than have it where the employee would have to use their own personal communication devices. So, chairs are going to recommend that we pass with amendments. I'll kind of read off all the amendments so you can get that clear. We'll amend the definition of employee to include a prospective employee who has applied for or otherwise actively expressed interest in employment with an employer. Would add a definition for employer-owned communication device to mean a device owned or whose cost is reimbursed by the employer. Would add a definition for mobile application to mean a type of application software designed to run on a mobile electronic device such as a smartphone or tablet computer. Would clarify that it is unlawful to require downloading of a mobile application as a condition of employment or continued employment. Would clarify that it is unlawful to discharge or discriminate against an employee who, quote, has refused to consent to the downloading of a mobile application, unquote. Would delete the exemption for mobile applications required as a condition of employment and related to the functions of the employment position. Would allow an employer to require an employee to, quote, carry or use an employer-owned communication device that enables the employee's location to be tracked, and would clarify that a person rather than an employee can commence a civil action and make other technical non-substantive amendments. Do we have any discussion, members? Discussion? If not, recommend a pass with those amendments.
We're voting on the chair's recommendation to pass House Bill 1253 with amendments. All members are present. Any objections or reservations to the chair's recommendation? Otherwise, I'll cast an aye vote for all 5 members. The recommendation is adopted.
Thank you very much, members. We'll recess.